So the question is, why would a law firm not want to take on a case once a settlement demand has been sent to the insurance defense attorney or the insurance adjuster? Well, in workers' comp, our fees are generally based on the amount of the settlement. It's called a contingency fee, meaning you don't pay up front, but we take a portion of the settlement on the back end. Usually when there's a split between the attorneys have to fight over what their contribution was and why they should be entitled to the percentage of the fee that they want. So for example, if you have an existing attorney, you've been to doctors already, you've seen a QME, you've had your deposition taken, maybe you've gone to hearings, you're deemed maximum medical improvement, which means your case is typically in a position to settle, there wouldn't really be a lot of work done or work left to be done for the second attorney. So if a second attorney were to substitute in and take over your case, essentially all they would be doing is finishing up most of the work that was done by your prior attorney. And so it becomes a question of, is it worth their time and effort to actually sub in? And can they in good conscience actually add anything of value to you? There's a lot of times in our office, we get cases where people are already almost all the way to the finish line and they ask us to help out in the case, and we don't think we can add value. And so we don't want to waste their time, and we certainly don't want to waste ours as well. And so sometimes we'll say, hey, you know what, you're better off with the current attorney you have. You're in a position where maybe you're set for trial and switching attorneys would be disadvantageous to you, or there's some other reason there. But generally speaking, once the case is already to the finish line, it doesn't really make sense for a new attorney to join in unless there's some issue there. There are cases where a case has been pushed almost to the finish line, but we see that there's issues that still haven't been addressed, and they're majorly important to the client's case. And so in those cases, we will take over. But generally speaking, attorneys will only substitute in on the case when they feel like they have value to add, or there's still work to be done on the case. If the case is already in a position where it's truly ready for settlement, there may not be enough there to justify an attorney substituting in.